Hi, everybody. I'm grateful to be back with Kelly Burke, who's a representative for the state of Illinois from the 36th District. Thanks for being with us.
You're welcome.
Today we're going to talk about some of the parenting time issues and some of the new legislation that's being proposed with regard to this. And Kelly, it's interesting to me because as a practitioner, starting in 2017 when we got these new child support guidelines, all of a sudden there was a magic number.
Mm-hmm.
That magic number was 146 overnights. Now, I might be naive, but I'm still not sure as a practitioner what an overnight is. So I don't know if that happens at 2 in the morning, 3 in the morning, but beside that problem that I have personally, we'll get over that. And talking about 146 overnights because child support can deviate or get to another level of an equation if somebody who is the parent without the majority of time gets to that magic number, their child support goes down.
Yes.
And so that's been an interesting change, but following that change, we've now seen some bills and some evolution that's occurring with regard to some presumptions about percentages of time. Can you tell us a little bit about the history of that?
So there's currently filed in the legislature a bill that would put in a presumption in all parenting time cases that each parent should be entitled to 50% of parenting time, and that the judge would be able to award less after looking at a bunch of different factors that are very similar to what we currently have. So there's opposition to that. The sponsor's not been able to successfully move the bill. I believe he is trying to work through some of those objections, but this is not the first time that a bill of this type has come up. When the Marriage and Dissolution of Marriage Act was rewritten in 2015, the original language, as originally filed a little bit before that, was that there should be a presumption of 35% parenting time. And that ran into some of the same difficulties that 35%, that the 50% is running into. Okay. And so as we worked through that entire bill, it became apparent that some of the groups that we needed to pass the bill, all the other changes in the bill, many of which were just really good and needed, their opposition to that parenting time provision was so strong that it was going to not let the bill move forward. So we made the language about the 35% less mandatory and made it as kind of a recommendation or just a recognition that the more time children spend with each parent, the better off it is for the kids.
There are certain factors under the current bill that's in place that says that the court has to consider these factors, but the court's not mandated to look at any one percentage as the bill is written and adopted now, effective January 1, 2016.
Exactly. So it leaves a lot of leeway to the parents. And just keep in mind that parents can agree to anything. So if you have parents who they want 50% each, then they can work on that. These are really the contested cases where one party, the other wants a different arrangement.
And there may be different history, there might be different evolution of that family, different job types, different responsibilities for other areas of their lives that can impact that as well for parents. And that, I think, needs to be one of the considerations.
Yeah, and I think there's a consideration too that sometimes these are situations where it's not necessarily, a family that's lived together as a family unit their whole existence. Sometimes these are situations where one of the parents has not been in the picture.
Sure.
And what's appropriate for a family that's been together but now just is breaking up, it might be different. So there's a lot of those types of considerations too.
Now, under the new bill that was proposed that's not in effect right now, that 50-50, it's almost like they want to adopt a one-size-fits-all.
Yes. And I think where this arises from is there are parents, in my experience it's been mostly dads who I've talked to who have had this experience where they feel that they were not heard in their custody situations, and that they were not really recognized as being a valuable parent, and just not given the amount of time with their child that they feel is appropriate to build that parent-child relationship, and it's really been difficult for them.
And was that the drive, you think, for that movement?
That's the drive for this, but I think where we need to look, because you hear a lot of anecdotal about certain cases where people aren't getting this, but I don't know where it's systemic, because you hear from many, many practicing judges that they say, well, no, in my courtroom, I'm always open to a 50-50 if it's appropriate.
If it's appropriate, right.
I'm always, and so I think that would be a really good place to look, is maybe look into whether there are certain counties or circuits or somewhere where that openness is not happening, and then maybe we look at how to address it instead of just putting in a blanket 50-50 that would apply to the whole state
across the board
in every single case.
Did you see any other difficulties with the presumption of the 50-50?
Well, there are some questions that have been raised about families that are receiving benefits,
Sure.
Nutrition assistance, housing, anything like that, it may jeopardize the parent who's receiving those.
50% of the time. Yeah.
I've not seen any definite research on that. I think that's something that is being worked on by some of the advocacy groups, but that really would not be beneficial for that child.
Right.
Yeah.
And then the other thing is that there were some instances in domestic violence cases.
Yes, exactly.
Can you talk about that?
So I would say one of the most vocal groups opposing the 50% presumption were groups that advocated for people who are victims of domestic violence. And they just really felt that this could be used as a tool by an abuser to control, intimidate, harass.
Sure. If you file
Exactly.
something, there's going to be this presumption
Exactly.
that goes into effect. So at this point in time, as the bill was drafted, were you a supporter of it?
No.
Okay. And what is the current situation? They're trying to reintroduce a bill, or?
We have, let's see, we're in September. Our session runs until January. The bill currently is not assigned to a committee. It's been moved back to the Rules Committee, and we're really not in session. We're only in session pretty much 2 more weeks.
Okay.
So the odds of it having any movement this calendar year are pretty low.
Slim, yeah.
But I would think that the sponsor would reintroduce it,
Okay.
and give another opportunity. And he's been, he's held forums. He's talked to different groups, and I assume he's going to continue to be open to hearing, how this might be implemented or changed.
Got it. But there also are a number of groups, including but not limited to the Illinois State Bar Association and other bar associations, that were opposed to the bill as well. Is
Yes.
that correct?
Yes.
So that is not anywhere near of something that will be the law immediately.
No.
In the near
No.
future. Well, it's an interesting change, because that presumption and those issues, clearly stemming from, our prior conversation starting January 1, 2015 to date, seeing that evolution come about.
Yes.
There really are a lot of changes. There's a lot to be seen. And also, what does that factor with the judge's discretion, and what do we do with those paradigm shifts?
Exactly.
And so it's going to be interesting to see how this all plays out.
Yeah, and I think, as you've said, as we've talked about in our past couple episodes, there have been a lot of changes in the domestic relations statutes over the past couple years, and it's going to take a while for it to play out. And as we get more experience and learn what changes we've made that worked and didn't work, again, we'll go back and work to tweak things to address any of the problems we have.
And I think that what's important also to know is that there's not anything that can cure every problem. Just because these changes have been made, in my experience, hasn't eliminated litigation.
No.
In fact, in some instances, getting clarification about the bill has spawned maybe additional litigation, which wasn't necessarily the intent.
Right.
And something that's really interesting is that they don't have a residential parent under the new bill, and yet in one of the cases, they agreed on everything, but because it didn't have the residential parent, except for school purposes designation, the parents started fighting over that.
Oh,
so
right.
the one thing that was supposed to be the easiest part of the bill
Right.
became an issue. So, everybody has their own perception, their own window pane that they look through, that they see the world through. And so some of this is not going to avoid those conflicts.
Right. And in domestic relations cases, I think more than most other areas of the law are so fact specific
Very much
that
so.
you write legislation that you hope will address the overwhelming majority of cases,
Right.
but there's always going to be those outliers out there.
Right. So as our wrap up today, just so that everybody's clear, right now the parenting time statute allows the court to look at various factors and come to a conclusion about what they think is in the best interest of the children.
That's correct.
Very good. Well, I appreciate your time today. It's always good to learn about what's happening in Springfield and to know that family law is a priority.
Yes, it
I'm
is.
grateful for that.
Well, thank you.
So I
Thank
appreciate
you.
your time and your efforts on behalf of our community.
It's my pleasure.
Thank you.
You're welcome.